Ms. Deb Sabaris, welcome, and Ms. Harriet Bellett, thank you for coming. Information on parliamentary privilege and the protection of witnesses and evidence, I believe, have been provided to you. Right, good. Okay. The committee has your submission. I now invite you to make a short opening statement, one or both of you. At the conclusion of your remarks, I'll invite Senator Moore, the other member of the committee, to put questions to you and me. And for the Hansard record.
Never in that order.
What?
Never in that order.
That was the first committee I've chaired, so the rest with it. For the Hansard record, would you please state your full name and the capacity in which you appear today?
My name's Deborah Sabaris. I'm the CEO of the Centre for Excellence in Child and Family Welfare.
My name is Harriet Bellett. I'm a policy officer at the Centre for Excellence in Child and Family Welfare.
Well, you're welcome to make an opening statement.
First of all, I'd like to acknowledge that we're on Aboriginal land here in Victoria. Welcome to those who are Victorians. This is the Wurundjeri land. And to acknowledge elders past and present and elders here with us today. I'd also like to acknowledge my colleagues behind me, Chrissy and Frank, and who I just have to say we feel very strongly about in terms of the amazing work they've done.
You don't have to for 1 second about the worth of those two people behind
I just managed to have her to myself just for 5 minutes, so I'm very lucky. She's normally got some people around here, so I just want to acknowledge them. But also, just I'm sure lots of people have said this today, acknowledge a landmark Royal Commission. Having gone to other parts of the world, they're very jealous of our ability to undertake something so amazing. And we'll talk a bit about some of the other issues, but I think that we need to put that on the record. From our point of view, we represent over 100 organisations here in Victoria who work with vulnerable children and families, with lots of students and individuals who are members of our organisation. And the Royal Commission has held our attention and the attention of the organisations that we work with for the last few years, and has given us a very strong, I suppose, navigator in terms of what we should be doing and what we shouldn't be doing here in Victoria. And from our point of view, we have certainly advocated long and hard that the scheme should have been broader and that the compensation should have been much higher. And so we continue to be quite disappointed, and so do our organisations, about the scope of the scheme. And we'll continue to say that for as long as people like you are prepared to listen to us. So then, really, my opening remarks, we thought we might, it'd be for us preferential to get you to ask us questions, because we've put in quite a short submission. We've been listening to our colleagues, and also we had some other colleagues here this morning. I believe BACA were here, our Aboriginal colleague organisation, so I'm sure that they put forward a very strong case.
You weren't here this morning, but let me start by saying that we have this elephant in the room, and you mentioned in your submission, you said then again, it should be broader and higher. It should not just be sexual assault. It should be an institution should be looked at. It should be physical assault. It should be emotional assault, emotional abuse. It should be, in my opinion, it should be children who are treated as child slaves in institutions. All that should happen. But unfortunately, it hasn't, and our terms of reference don't allow. I have moved a notice of motion in the Senate for Royal Commission into the clammies and all the other forms of abuse. I did say this morning, and I'll reiterate it, that the line is so blurred that when a Christian brother strips a 13-year-old boy naked and whips him on the bum, that, to me, constitutes sexual abuse, not just physical abuse. It's both. So that's where we have, I used the word shackle this morning, and I'm sorry we're in that situation, and we're trying, even on things like the $200,000. We pledged at a meeting last year, when Mr. Golding was there, try and get it back to 200, because that's what the Royal Commission said. And somewhere, somehow, we do not know, I've asked the Prime Minister's office, who brought it down to 150. We suspect it was government collusion with the government of New South Wales to swing it in. We've since been told that if we try and fight it any further, it'll put off anything for 2 years and more people will die. So we've had to bite the bullet and just slow it 150. I don't like it any more than Senator Moore does, but I said, well, let's, they say they're compromising Canberra, and you just try and get what you can. That's all I can get them. We can get them. So anyway, I totally empathise with you if the Royal Commission findings, the spirit and the wording of Commissioner McClellan was, and we had a private meeting with him the other day, if his drive and his beliefs were replicated in our redress committee, none of us would have to be sitting here. So there we are.
I suppose the issue for us is it's now a very complicated scheme because it has a very narrow focus, and we are very concerned for very elderly victims, because of the complicated nature of the scheme, and we're all trying to make sure our agencies join this scheme. They're trying to figure it out too. But I would hate to see victims die before they get some level of compensation through this scheme or through civil litigation.
Well, sadly, some of them have, and some more will. And that's our job to try and work out
So this
how we
inquiry
can
is very
mitigate
useful.
Yeah, as by Deb and other people that have spoken today and in other submissions were deeply unsatisfied with the 150,000. But even within the 150,000, the arbitrary table of types of abuse is problematic, and we've heard that the average is going to be 76,000. Not from reading the chart, it's not really clear where that average would come from, and I would be very interested when the reporting process is undertaken for there to be to be reported what the average actually is going forward. So that's something we would like to see if it does actually track on that, and the reasons for why. In particular, in order for the abuse to hit the repetition of extreme circumstances, the clause of institutional vulnerability appears to provide some problems in that it's not clear what would need to be satisfied for somebody to be deemed institutionally vulnerable. And some of the assessment framework discusses the need for somebody to have been not reasonably leave an institution, but that term not reasonably leave also is very open. It's how is somebody assessed as being able to reasonably leave as a child in a school, reasonably able to leave that situation. It's very unclear, and our worry is that whilst the 150,000 is not the 200 that the Commission recommended, it seems unclear how many people will actually even be able to get 150 if that institutional vulnerability section is difficult to assess.
In your capacity, have you found that the argument come up a lot of what was this morning, the expression of penetration? Every witness that has from which he said, how can they make this distinction?
Yeah.
Have you found that?
Well, the Royal Commission found it itself, but a victim's response to the abuse that they incurred varies enormously. So it is an interesting way in which this has been defined, because not everybody who's had penetrative abuse has had the same reaction as people who haven't. I mean, the problem is that in many ways, the consultations around this, I'm sure, weren't done in the way that I would want them to be done to ensure that this reflects what victims said, about the way they would like the compensation to look and feel. And certainly in Victoria, there was very little consultation that I'm aware of, particularly with organisations who might have been able to pressure this accordingly.
Well, it reads to me like it came from bureaucrats' pen.
Yes, and the abuse types pay no regard to intensity, time frames, impact. It's simply about types, and that just seems unsatisfactory, given what we know about the survivors and the complexity of their experience.
To me, this is a very dangerous
It's a very sophisticated, one would think with the World Commission who that we should ask them to do this really. But this is not what we would approach with.
So a nine-year-old boy forced to perform oral sex on stage is affected as somebody who's penetrated. That's what they're trying to tell us.
I do believe that is actually covered in the rules. I think that is classed as penetrative abuse.
Is it on?
Yeah. So I agree with your sentiment, but yeah, that particular one I do believe is classed. But I mean, I've spoken to the redress team at the Commonwealth, and they've advised me that this amount of redress attention is actually only a guide with the wording that's been
not out in the state.
Yes.
But how strongly will that be followed?
Exactly. Yeah. So that's another area of non-clarity for people, and it's helpful if this was only a guide. Has it been helpful for victim survivors to.
Two quick questions I've asked everybody. One, have you had any Centrelink connections? Because everything has to go back. Somebody that's the magnet and always to go back through there. And I'll do that one first.
No, and we're a state-based organisation, and we have got two ways of navigating the scheme. One is through our state colleagues, so the Department of Health and Human Services here in Victoria, who say that they are also a participating organisation, so we need to then go to the Commonwealth to have a conversation with them about the scheme. So this isn't it's not connected up. That's the first thing. So we would rely with our Commonwealth colleagues to engage through Centrelink. So no, Senator, not at this stage. We haven't had a direct, but I'm sure it's coming. I'm sure we will have to have some conversations with them directly if we don't get the satisfaction we need through the Commonwealth Department.
Okay, and the second thing is, what's your reaction been to the 49-page application form? We've been told it's a work in progress. We've been told in every meeting we've had that it's a fluid document. It's been changed. Hasn't been changed yet. But what's your experience?
Well, I might react a bit differently. I think that I would find filling in a document of that magnitude, if I were a victim, really difficult. But I'm not sure what victims groups are saying about the document. I'm sure they're saying it's too long and it could be much shorter and made much easier. Given that this is meant to be an easy scheme with a low benchmark, the form is too long. But all of the complications around this, Senator, if you get online, we're trying to understand this as an agency. We're trying to work out how much money they have to put aside to participate in the scheme. It's a nightmare. So all around, all of the administration around this is, it was late. We still don't have answers to questions, and we're all floundering around in the dark of this. So we would have thought that as soon as the scheme was announced, all of this would have been worked out for both victims and organisations who want to become and will become participating organisations. To make it short for the conversation, all of the administration around this, all of the questions, we've very much struggled to get answers, even though everybody's very nice. When we pick up the phone and talk to you, it appears that sort of things are evolving and questions are being answered as we go, and I just think that's less than satisfactory.
One of the issues that has come up consistently is people's awareness. I hesitate to use the word consultation because it really does have mixed definitions in terms of what that means. But your point about not having information and not having a place where an organisation like yours, which has a wide membership of community organisations, all of whom I would think at some stage will be involved in some way or another. It's not the direct clients, but family members. It's just by the way community organisations operate.
So it's also very important for them as well. I mean, it signals something really important, I think. So apart from anything else, they're on the phone to us every day asking us questions and trying to find answers. But yes, absolutely.
How do you think the communication sharing, the education and awareness for organisations, how do you think that should work?
Well, certainly, it shouldn't rely on somebody having to ring, DSS to get information, and should be a lot more outward facing. And my suspicion is because there isn't enough information and so many things are sort of evolving, the outward facing communication has been limited. But I would be using community service organisations across the land to push out information about this. We hear anecdotally that through some of our organisations that they expect today and tomorrow and next week and a few weeks ago that families are talking to their loved ones who have been in institutions and trying to find out what might have happened, because mum or dad may have never spoken about it and may not have given any evidence at all. So there is a conversation with people's loved ones about did something happen. So word is getting out in the broader community, but it's happening just organically. In the institutional setting, they're being much more because they're looking through their records to try and look at where there have been clusters of children who might have been together, assuming that they need to do something about that. Searching for those 4 or 5 years anyway. But certainly there's not a lot of outward-facing communication that would give you confidence that this is something that we all we all know what's going on and we all know what's going to happen. Maybe we don't have all the answers.
Has your organisation been approached by government to help share information? Have you been formally approached, given your name to begin with, and secondly, given your membership base? Have you received a request from the federal government to share information and to raise awareness across your organisations and the families involved with your organisation?
No, in fact, we have chased them down, chased anybody down who will talk to us and talk to organisations so that we can get things moving. Particularly when we have organisations that, for example, didn't actually have children in care. The children were voluntarily placed into their care. So we've been working with them to get them some advice so that they can do that. So it's sort of an interesting time when you've got an organisation who didn't have to sign up quickly and wanted to, and we see that a lot, which I think is a testament to the work that's been done over the last few years. But no, we haven't been approached. We will continue to do what we're doing, which is to make sure that any little bit of information we get, we'll push that out. But again, that's not really appropriate, is it? I mean, what would be much more appropriate is a public awareness campaign that said, look, this is what the country's done, isn't this fantastic? Let's make sure that people, their rights are upheld and they get access to both the information that they need, the financial support they should receive, and the counselling they deserve. Here in Victoria, the Victorian government said that they won't really put a limit on the amount of counselling that victims receive.
They're the only government who has said that. The Victorian government is the only one, and I think it should be noted that they have led with that, because they've had their very strong state inquiry, haven't they?
They have. We also have very strong peak body that would be jumping up and down if they can do it. So like we as we go through this process of implementation of this scheme, there may be times where the Victorian government will need to step up and fill some gaps that the Commonwealth can't or won't fill. So, I mean, that's when you sign onto a scheme, sometimes then some of the things that don't happen, you need to do
something. Financial comments too. The thing about counselling, and I know that your organisation is deeply involved with the Centre of Excellence in this process, it's been raised consistently the concerns about the counselling model, and it's my understanding that Victoria has said that they won't be paying out lump sums. That they'll be.
The Victorian government will be allocating counselling services using their providers, but they're not handing out lump sums. But like Jen said, they are not placing a limit on what applicants can be provided with in terms of counselling.
Your experience in terms of counselling and the variation of counselling needs. I come from Queensland, so remoteness in Queensland is a little bit different to remoteness geographically in Victoria, but individual remoteness is not only geographic. Do you have confidence as an organisation that the Victorian resources of having a list of government sanctioned counselling options will be able to meet the needs of the people who will be identifying that they need counselling options?
No, not total confidence. We've some incredibly great counselling services that I think I would personally go to. So they'd be the ones I'd want victims to be able to access. I still think there's a few things. I think there's certainly a rural and regional issue here in terms of people accessing services when they need it. Then there's the expertise, and I think that we've got a handful of really great organisations, but I think we would still need to make sure that we could meet what I would call the expertise gap, as well as their geographical gap. But the people here in Victoria are working hard to try and address both of those things. But it's going to take some time.
Organisation involved in that?
We're involved in
a network about identifying counselling needs, identifying gaps, and trying to work.
We certainly hopefully will be with the Victorian government. They certainly seek our expertise and advice and input on all of those things. A few of our members are counselling providers, so we often go to them and say, what are you providing? What are you providing? Is it meeting our needs? Are there gaps? And then we lobby the government hard. So we expect to be quite involved in those conversations over the next couple of years.
We had evidence from financial counsellors earlier saying that that is a service they think, as a professional organisation, would be important in this space, that has not received individual funding to be engaged. Do you have any views on that? You don't have to have a view, but I mean, it was just read some evidence.
I mean, I think that for anybody who may or may not be receiving some sort of financial compensation, making sure services are available is a really good idea. But we've got to remember, for some of these victims, they're going to have families who are going to support them, help them through the process, so may not need it. But it's always nice to know that it's there. A lot of the financial counselling services here in Victoria are heavily patronised by vulnerable families who might need a range of supports. But again, I mean, I think it's counselling colleagues, peak body colleagues are gone now. I think that it is a horses for courses thing, though, and I think that it gets back to your early comment about, well, if we were engaging appropriately and had a bit of a public awareness campaign, we would be much clearer from victims and families what was needed. Part of the problem is we're sort of guessing. We would not have a clue how much extra financial counselling we need. We just wouldn't, we don't know. We certainly need more of that anyway in rural and regional Victoria for general purposes.
The department in discussion with this committee has said that they are seeking ways to ensure that people know about the services and know about the program. We are consistently amazed with 10 years now of discussions with Senate inquiries and Royal Commissions that there are still people out there who do not know that they could be impacted by this process, and that will continue. I am surprised that there hasn't been a call to local organisations to say, how can we market this? So that's something we'll take on.
That would be terrific. There's a patchwork of organisations, victim organisations, we want to help, we absolutely want to help.
And then the other issues you raised, we note because it's been raised a lot. Is there anything else that you want to put on record? I think
I suppose
you know what you want to get.
Well, I suppose from our point of view, DSS do need to lift their game. It's about not having to be chased by Harriet, who chases them all the time. But the other thing I will say is there is definitely an interplay between civil litigation and compensation through the scheme, and victims' choice to go the civil litigation route versus the sort of redress route. Most of the civil litigation claims have been much higher than anywhere near those that might be received through the redress. And anecdotally, we are hearing that the payouts through civil litigation are climbing, given the environment that we're in, and the recognition of the abuse that victims have suffered. So there is definitely something to watch there over the next little while.
What you're saying, because in your submission you talk about having people have to navigate, was the word you used, navigate between a disappointing redress system and the civil courts. The word we talked about in the earlier testimony today is that the feeling is that because of the low redress payments and because of the levels have come down and the average might be 75, 76, but maybe 35 or 50 or 20 or 5, that it's causing some concerns about the civil courts being polluted by the low levels of redress. And so people are now scared that if they go to the civil courts, they may get even less and half it goes in, or 3/4 goes in legal fees anyway.
Well, certainly, anecdotally in Victoria, the payouts in civil claims are going up, not going down. The other complicating factor with the scheme is that for the most part, it's very difficult then to run a civil case for other things, even if they're not related. So I think that the navigating of this by lawyers and support people is really fraught. Because really, you're going to get one bite of this if you go redress. If you go civil litigation, you can take in the broadest amount of information in terms of the range of abuse you have suffered. And this is the sort of stuff that CEOs of NGOs are looking at, going, well, what's the likelihood here? Because for organisations, they have to consider the civil claim as well as a redress claim for all victims. You know, it's going to be up to the lawyers and the families of these victims to work out which path they want to go through. And that will depend on the ones who've taken payment in the past and signed one of those waivers where they have no idea what was happening in the future and could have been under that group is very vulnerable.
I make a civil action if the lawyers take most of it anyway and back to where I was.
I think that some of that back in those days, yes, Senator, but it might be a bit different now in terms of the awareness on these sorts of issues. But you're right, there would still be some people who might be taken advantage of in this sort of environment. We would hope not.
Which is part of the awareness raising and those things.
The more you bring it to the surface, the more likely people will have all the information to be able to make good decisions. The other very quick point is that here in Victoria we have I just need to put it on the record, we have a public insurer called Linear, who insures all NGOs for any sort of legal issues. And so it's a public insurer under the state government. And I think that for our providers, they were of a view that the public insurer redress payments. That is not the case. So I don't know what it's like for other NGOs across the country, but none of the NGOs in Victoria will be using any sort of insurance in order to pay their claims because they will not be covered for redress. It's very interesting. And I think we're quite unique in Victoria in having a public insurer to make sure that people can be and so all the these are just
Well, are you finished? I'm finished. Thank you very much.
Thank you so much.
Appreciate it. Thank you.
Good luck with things. Thank you.
Now, I'd like to welcome representatives from Setting the Record Straight for the Rights of the Child Initiative, and Professor Joanne Evans and Dr. Gregory Roll. Good afternoon. Good afternoon. Now, I'd just for the record information on parliamentary privilege and the protection of witnesses and evidence has been provided to you both, I understand. It has, that's good. Committee has your submission, obviously. I now invite you to make short opening statements and the conclusion of your remarks. I'll invite Senator Moore and ask the question, including me. So for Hansard record, would you please state your full name and the capacity in which you appear today?
My name is Associate Professor Joanne Evans. I'm from the Centre for Organisational and Social Informatics in the Faculty of IT at Monash University, and here as convener of the Setting the Record Straight for the Rights of the Child Initiative.
My name is Dr. Gregory Rowland. I'm a research fellow at the Centre for Organisational and Social Informatics at Monash University, and I'm the research fellow on the Rights and Records by Design project looking at record keeping rights for out-of-home care.
Well, you're welcome to and you're welcome to give an opening statements.
So for the opening statement, to start off with just a little bit of information about the Setting the Record Straight for the Rights of the Child Initiative. It was established to advocate for the record-keeping rights of those who experience childhood out-of-home care and to transform record-keeping and archiving in the sector to better respect, represent and enact those rights. It was formed in partnership with key community advocacy organisations, Care Leavers Australasian Network, CLAN, the Child Migrants Trust, Connecting Home and the Create Foundation, and the Allied Research Unit, Australia's Collaborative Research Centre in Australian History, and the University of Melbourne's eScholarship Research Centre. We held a national summit at Federation Square here in Melbourne in May 2017 to highlight the record-keeping and archiving challenges for childhood out-of-home care. That resulted in the development of a 10-year action, advocacy and research plan for overcoming the systemic and enduring problems of record-keeping and archiving that the Royal Commission highlighted. Begin with the general comment. While our focus is on record-keeping matters, we would like to start with expressing our disappointment at the inherent unfairness of a redress scheme that is limited to child sexual abuse. We join with many others in reiterating the need for redress for all members of the stolen generations, former child migrants, forgotten Australians and care-leader communities who have experienced abuse and neglect while in institutional or other forms of out-of-home care as children. On to the significant record-keeping and archiving matters that this redress scheme, and indeed any redress scheme, would need to address to be survivor-focused and trauma-informed. It's vital that the process of applying for redress should not replicate existing power imbalances around records and cause re-traumatisation. Our first concern is in regards to institutional record-keeping and archiving. Governments and other organisations have agreed in principle to the set of record-keeping principles for child safety and wellbeing recommended by the Royal Commission, Recommendation 8.4. That includes Record-Keeping Principle 5, individuals' existing rights to access, amend or annotate records about themselves should be recognised to the fullest extent. For redress, we need to move from in-principle support to demonstrated implementation. We must ensure that backlogs in documenting and providing access to records does not adversely affect survivors' ability to apply for redress and receive the appropriate compensation. Increased demands for access to records must be adequately resourced, along with the funding of support services to facilitate the process for survivors. We note the comment that the Royal Commission made in Volume 8 of the final report, saying that they received more complete records about individuals than the individuals received in response to their own access requests. This is unacceptable in the context of redress. So we ask this committee to inquire into where access to records may be having any adverse impacts on redress applications and outcomes, and explore what the scheme has put in place for monitoring, mitigating and resourcing. A further issue with institutional record keeping is around the provisions being put in place for setting institutional records straight as part of direct personal responses. These need co-designing and independent monitoring and oversight if they are to be survivor-centred. For those with out-of-home care experiences, we would also like to see right to reply extended to having a say over the ongoing access and control of their case and other records. Our second concern is with the record keeping of the redress scheme itself and the need for survivors' co-creation rights to be reflected in its design. Survivors are yet again having the intimate, sensitive and personal details of their lives captured into institutional record keeping systems. They must be given the right to oversee and control the further use and management of this information, including long-term archiving. We note that while assurances of confidentiality have been given, there is no explanation of the long-term fate of these records on the redress scheme form or website, or that we couldn't locate. We therefore ask that this committee investigate the mechanisms that have or are to be put in place for the long-term disposition of the scheme's records. And we advocate for these to be survivor-focused, providing applicants with the choice as to whether details about their sexual abuse will one day be on the public record. We note that this is highly individual choice which needs respecting. Neither a blanket, permanently steal or destroy records nor preserve a records policy is acceptable. And just our third and final concern is with the degree of survivor community engagement in the detailed designing of the redress scheme. Greg and I are information systems designers. We know how exclusionary processes can be and the impact that then has on outcomes. One of the features of the Royal Commission was the deep engagement in the establishment and implementation of the Commission's processes with survivor advocacy organisations, contributing to the quality of its outcomes. And so we ask that this committee investigate how the survival-focused principle has been implemented in the design of the redress scheme processes and systems to identify the barriers to the kind of community collaboration and co-design that many were expecting in its formation. Thank you.
Okay. Apart from your concerns about record protection, we'll get back to that later on. I had to raise it with other people, and those in your submission, about the scope or the lack of scope of the Royal Commission. Is that we are restricted in where we go. What Julia Gillard said, Prime Minister Gillard set up was only sexual abuse in institutions. We have a notice of motion before the Senate for a separate Royal Commission into the crannies. The fact that all the other physical abuse, emotional abuse, child slavery, the workforce and institutions, that all must be recognised in some manner or form. But if we try to do that now, or extend this Royal Commission, it'll be another 2 years before anybody gets any money at all, and more people will die. So that's the problem we have to face on that. I hope you understand that.
Yes, we understand, and we will keep on stating.
Yeah,
Approximately,
as you should.
yes,
And,
yes.
it's probably worth reiterating what Frank Golding said this morning, that there's been a number of royal commissions, and the redress schemes could have been set up to address all of the findings from bringing them home onwards. So we're not saying that the scope of
We're not getting the argument on this table,
Yeah.
because the material is there, was there, and it could have been done. But some of us in the media, I was in the media at the time, we got blown away by the fact that something was finally happening. We got the Victorian one up, then we got a federal one up, and we all thought, here we go. And unfortunately, a large chunk of people, hundreds of thousands of people, were left aside and then you spent, Frank with the readers, you spent 5 years watching all of us saying, isn't this going well, even though it's awful, but at least something's happening, when a whole swathe of people were being totally ignored and left aside. And I'll concede that straight away. And where we go from here, I don't know. With the record protection, would you acknowledge that, and I said this morning, I don't know if you were here then, Dr. Rowland, but if I'm an institution and I have been told I have to pay $45,000-$50,000 to somebody for something happened in my institution, aren't I entitled to know what the allegation is and by whom?
Yes, I mean, I think that's the process has
Well,
to
that's the
do
record
that.
that you're worried about. You're worried about where it'll go after that.
Yeah. Well, I guess it's what agency and control the person has of that process, because you want this to be a trusted process. You want you to feel that you're in control of that process, not that you hand it over and then it goes off to someone and you don't know when that person, who it is accessing, what are they doing with it. You don't have any insight into that system. So how can you make it transparent?
As a victim of that institution, you're not exactly going to trust them instantly, are you?
Exactly. No. So how can, I mean, that's why I think this issue is just one that needs to be really carefully designed as a process, and a process which builds relationships and trust and involves the right people to facilitate that through.
Right, I came again this morning, so therefore I'm an institution and I'm going to pay $50,000. If I have an insurance company, and they ask me, they say, we'll know what you're paying for.
there is and again, we're limited by the scope that was set up by the Royal Commission itself in redress. But there's the example of, and it's a slightly different set of circumstances in England, the out-of-home care redress scheme that was set up on the basis we presided over a broken system that resulted in abuse. We exposed you to that abuse. We're not going to go into details of the particular abuse, but you were exposed to this system, and whether it was abuse, penetrative or not, or you were in the shower stall next, or the bed next door, or whatever, you were still part of that abusive environment. So we are going to provide you with redress, not based on an adversarial claim of a particular action, but the fact that the system was mismanaged and broken. I'm going to do it that way, which is actually far simpler and speaks more to an admission of systemic problems than particular accusations at a particular time and that kind of thing. So there are other models of redress that are possible and internationally have been.
But the Royal Commission also acknowledged that, didn't they, in the way by saying that you don't need proof as in a court of law. The bar is much lower in the redress scheme than it would have been if you were in a civil action.
And that belies the 40 odd pages.
Yeah.
And because of supporting documentation that you're asked to provide, it's like, but without any clue as to what exactly should you be providing. It's like,
Well, we have one earlier today, which is sort of sum things up. When if filling in that 49 pages causes you trauma and causes you awful angst, but you can't get any counselling because you're not signed up yet, which just sounds crazy.
There's also, and I think Senator Moore made the comment this morning about is there any good form in the public service? There are some specific design aspects of the form that and we've heard pros and cons about about that. But for a form that information and speaking to things about sort of reforming, if the form is designed to hoover up information, it's not particularly directed, and so you could construct a form to say, were you here at this time? What institution were you in? What day? Please provide the documentary evidence for that. Not a series of sort of big blanket questions and then attach all your documentation at the end. I think that comes part of the trust thing and possibly part of the co-design thing, and specifically targeted questions to focus on that narrow scope of where the bar evidence actually is, and then provide the documentation for that.
Process as well too. It's like that there's an initial I'd like to apply, and then a process of actually building up to that. Now we've got all the information available that it's going to go off to an assessor about it. So it's not just send it all over and then get an assessment back.
And be assessed.
I think one of the things I think we have managed to achieve, I think, is that this idea of having to relive your experience and fill it all in again. The idea that if you've done a stat deck or you've made a statement to a private session with the Royal Commissioner, or you've been at the Commission and given public evidence, that should be, you should just have to be able to put on your form, C attached, and that should, so you don't have to relive it and do it all again. I think that's would be good.
I mean, as you know, with the series of Senate inquiries we had, records were consistently in the top two issues that were raised. Every inquiry, didn't matter whether it was institutional care or forced adoption or out-of-home care, accuracy and ownership of records came up every time. So when your organisation was set up, there was a lot of joy. That finally, instead of having to have these battles consistently with state groups over and over again, at least someone was looking at the wider context, even though the end delegation was always going to be Queensland birth deaths and marriages or Christian Brothers, Tasmania or someone, at least the issue was taken up. So I think the fact that you exist is something that everyone can agree is a really, really positive step, and I hope you get that back from people because it is so important. In being set up and also having the launch and so on, was there federal government involvement in that?
No, because we have set ourselves up as a grassroots community organisation. It's like the most important people to have involved in that process was the grassroots people. Yeah, we don't necessarily see ourselves as, we see ourselves as perhaps working with those other government institutions and agencies through time, but I think for the initiative it has to be an independent initiative, it's like, and so that's how it's been set up.
The reason I ask is that considering the expertise that you have and the way you've just discussed, Dr. Rowland, the options to the way you could design forms in a process, it's a resource that the government could have been able to use when they were struggling with how they would set up the scheme and set up the forms and so on. It's unfortunate that there wasn't that shared, at least a shared discussion early in the process, and we've missed that, but it's not a fault. Now we can actually make sure it happens in the future. But I was just wanting to know whether there had been that awareness of what you were doing and the skills that you had.
Not for the redress scheme. I mean, we have had working towards the summit with the East Scholarship Research Centre being the Find a Connect web resource people. Then through them we were in contact with the CSS people there, and a few came along to the summit. But it wasn't an official relationship. It was just because yes, they're a stakeholder in this, to be there to talk about what are we going to do about these systemic and enduring problems.
So in terms of the scheme, I think it's a bit of a hybrid of the two. The scheme that the Australian governments have accepted is not that just proves that you were there, and the fact that means that you're in a situation where abuse was likely to occur, which was on one side, or a directly legalistic, you must prove you have it. What we come up with was somewhere in the middle, which is probably not pleasing to everybody, but it's where we are. So it's neither one nor the other. But I am interested with that ongoing program with records and with the Privacy Act, that records can only be used for the purpose to which people have agreed that they can be used. And that's used all the time in the government, that unless you know how your records are going to be used, they shouldn't be used. And I'm interested, and I do not know whether the Royal Commission had rules that were clearly understood by everybody that came to speak with them about what exactly was the ownership of any statements that were made and what was going to happen with them. I would expect they would have had to, in terms of the privacy
But they didn't.
legislation.
With the Royal Commission and the private hearing testimony, actually in the changes they made to the Royal Commission Act to deal with that was to have that testimony under closed for 99 years and then public records. And however, when I was looking at the information on the website, I could not find where that was publicly stated. I knew about it, but it was not necessarily when you sort of went to have a look at if I'm going to give, if I want to do private testimony, this is going to be, it might have, I think it did happen in the process, but it wasn't out there.
With the Royal Commission, because I think that's really critical, because it's my understanding, and that's why we go through the palaver at the start of all of our, even though you go, there's no one listening, that's why we go through it at the beginning of every hearing. People know, what the rules are, and if they have you received information about, so that, and I would expect at the Royal Commission, everyone who gave testimony got a piece of paper that spelled out what the rules were, whether they knew what it said or looked at it at the time. That I'm pretty sure just by the law they would have had to have that exchange.
So you're guessing.
And then what happens to it in the long run? I would expect there's archive acts that actually say where it goes, but it is interesting because we're doing the same thing. We're saying that people can attach their testimony from the Royal Commission to their application for redress. I think there has to be some kind of agreement around that as well, because that's the purpose that they were not told was the purpose of their appearance at the Royal Commission. When you trace it all back,
and that's what's missing in the redress scheme is what is going to happen to those records. And the Canadian example that we talked about in our submission, I think, is a precedent to sort of work with, where in their independent assessment process for residential school survivors, they didn't specify what was going to happen, and when it came to the end of that and the default setting was destroy after 15 years, people said, well, no, this is a really important archive, historical record, we need to keep it forever. But then there was, but you haven't told people that when you ask them to tell their story. So that sort of, arguments on both sides, compelling arguments on both sides, which was resolved through the court process, eventually saying, no, you have to give them the choice. It's like, and not only do you have to give them the choice of whether they want to have those records archived, but also where as well too. So, I think from my perspective, who believes that we should have multiple rights in this kind of record keeping into the future, the precedent of that is telling. It's to say these, even though you're involved in a government process, these are your records, and so you get that say over them.
It's also, there's been the end of the ownership, or does it belong then to the nation, or to the, there's all kinds of,
See, that's what they're saying, that after 15 years, if you can make a decision and give people time as well to make that decision, because that decision can change over time. But to actually say, yes, if they do not want their record to be archived, then it will be destroyed.
Yeah, just 99 isn't all that long, really. It's long enough for my grandkids to see what happened to me, and
See, one of the reasons in the institutional care inquiry and also in the forced adoptions inquiry that there was funding to oral histories for the National Library was to allow people the option to take part in the oral history program, which is now at the National Library around institutional care, and many people took up that personal opportunity. So we do have this wealthy record of people who've chosen to tell their stories through oral history, which negates that, what you use your evidence for. That your submission has actually made me think about that wealth of knowledge involved in the Royal Commission and what will happen to them, because that's living history. And we've got to, and that's why we did the National Library project, that there would be an element of the living history of what happened in institutional care. So,
and I know that as the Royal Commission came to a close, and the usual thing that happens with Royal Commission websites is that they disappear and go into the archive. That strong, no, we need it there. It's like, and I think that's the thing. I know as someone who has relied on the being able to access the reports from previous inquiries is really important. You've got to keep them in the forefront of your mind. Otherwise, because that's the standard practice. It's like so, and it's just I just, it's so important that it stays there as these recommendations as all its recommendations are responded to and implemented, because it's just such a reminder of what's behind that. Right.
Speaking of records,
what do you think should happen? What to the records?
To the records in the redress scheme? Yeah. Well, I think people need to be explained that this is as this is a process. And this is a government process, then that means that these records have the potential to be public records at some stage. And so I think you need to actually have a choice, like as to whether there is a, like with the census form, we get a choice as to whether we're going to go on the record in the future for our descendants or not. So, I mean, I think that I think the most important thing is it needs to be talked through with the survivor organisation as to what's required.
As a matter of principle, when we're talking about, in particular, service delivery type records or that kind of thing, the body of knowledge our research has suggested, going back 25 years now, suggests that we need to be far more nuanced than sealed or public record. So there's a whole lot of granularity in the middle there about personal agency and the records about oneself. And so it depends.
And I'll ask you a totally different question. Speaking of records, do you have any liaison at all with Centrelink? Do they contact you? Do they ask you?
No, we're researchers, so no, not as researchers.
Okay.
And the Privacy Act has been, everyone wants the Privacy Act because it protects people's privacy, but consistently it's used as a barrier rather than an enabler. It's one of the great concerns. So,
Especially an acronym, was it FOSTA?
Yeah.
Because of the Privacy Act.
Because of the Privacy Act, and just closes doors.
Yeah, and it's one of the most misunderstood
Absolutely.
pieces of legislation.
But I think it's incredibly important to the work that you're doing, and so important for our history and for individuals, that how you actually get that sense of security in an area where there's been so little trust about what's going to happen to things. And also, we take your point very clearly about the lack of co-design and engagement. I think that's been an ongoing cry from people saying, we should have been involved. So thank you so much.
I think what Deb was saying just before about the, the Royal Commission was really special. It's like the way that, and in looking at what's happening in the UK and Scotland, the fact that, our commissioners were such a trusted group of people, they set up such a trusted environment, and so to make sure that the ethos with which they approach that is used in the implementation, is just so important. We can't lose sight of that.
President Evans, thank you. Dr. Rowland, thank you very much. Just before we wrap it up today, I'd just like to acknowledge that as I put on the record, actually, the extraordinary work that you, Frank Golding, and Chrissy Foster have done and continue to do, and you sit here all day through our hearings and listen to her, and you hear stuff repeated. I should acknowledge the fact that your work is recognised by this committee, and we thank you for it. Thank you. That concludes today's proceedings. The committee has agreed that answers to questions taken on notice at this hearing should be returned by October 31, 2018. So I thank all witnesses who have given evidence to our committee today. Thanks also to Hansard, thank you, and I now declare this hearing adjourned until Wednesday. Thank you very much.